Hello, and welcome to In the Privy Council, a podcast reviewing cases heard before the Judicial Committee of His Majesty's Most Honourable Privy Council, brought to you by the Legal Style Blog. I'm your host, Elijah Granite. This week, we're discussing the St Lucian case of Hilaire and Chastanet, the citation for which is 2023 UKPC 2022, LUC. This case deals with statutory construction and the strange places a plain reading of a statute can lead us. Before we jump in, I want to note that this will be one of the last St. Lucian cases covered on the podcast. In May 2023, His Excellency the Acting Governor-General of St. Lucia gave royal assent to the Constitution of St. Lucia Amendment Act 2023, by which the final appellate court for St. Lucia was changed from His Majesty in Council to the Caribbean Court of Justice. Of course, this did not change the status of cases already pending before the board, such as the one we discuss today, but it does mean that in future we won't be seeing any more St. Lucian appeals. Now, to the case at bar. One Mr. Hilaire sued Mr. Chastanet for defamation in the courts of St. Lucia, and under, as you might expect, the law of St. Lucia. However, Mr. Chastanet raised for his defense the serious harm threshold in Section 1 of the Defamation Act 2013. As many listeners will know, that act is not an act of the Parliament of St. Lucia, but rather an act of the Parliament of the United Kingdom. Now, Mr. Chastanet argued that a provision of the Civil Code of St. Lucia meant that the Defamation Act, passed in another country by another country's legislature, was also the law of St. Lucia. This argument failed in the High Court, but was successful in the Court of Appeal, from which Mr. Hilaire appealed to the board. The basis for this argument was Article 917A of the Civil Code, which provides that, subject to the provisions of this article, from and after the coming into operation of this article, the law of England for the time being, relating to contracts, quasi-contracts, and torts, shall mutatis mutandis extend to St. Lucia. Note the phrase, the law of England for the time being. Consider, is this an ambulatory phrase? That is, does it include acts like the 2013 Defamation Act, which are passed by the United Kingdom Parliament long after the Civil Code is written? Moreover, is the wholesale importing of foreign laws compatible with the Constitution of St. Lucia, which establishes St. Lucia as an independent and sovereign state? Section 40 of the Constitution awards the power to make laws for the peace, order, and good government of St. Lucia to the Parliament, being the House, the Senate, and the Crown in the person of the Governor-General. It also provides in Section 120 that the Constitution is the supreme law of St. Lucia, and that any inconsistent law is void to the extent of the inconsistency. Is that Constitution compatible with effectively letting the UK Parliament act as legislator in St. Lucian private law? One more thing before we turn to the board's decision. The Civil Code of St. Lucia anticipates conflict, and also provides in another section that where the law of England, imported by 917A, allows for a conflict with the Civil Code prevails. So the Constitution prevails over any other law, and the Civil Code prevails over any law imported by Section 917A. Now for the board, my Lord Lloyd Jones, and my Lady Rose of Colmworth, jointly considered these issues in turn. First, the Constitution. Mr. Hilaire argued that the grant of the power to make laws in the Constitution of St. Lucia to the Parliament of St. Lucia, by implication prevented the establishment of a parallel body, in this case the Parliament of the United Kingdom, which was also empowered to make laws. Their lordships rejected this submission. There is a long line of case law, see, for example, Ibralebe and the Queen, 1964, 2 Weekly Law Reports, page 76 at page 88, Privy Council, Ceylon, which interprets clauses to make laws for the peace, order, and good government of a place as a plenary grant of sovereign legislative power. And many of our listeners, especially those from Canada, will recognize those familiar words, peace, order, and good government. Now, thus, as a sovereign state, St. Lucia can use that peace, order, and good government, that POG power, to structure its laws however it likes, including by delegating legislative power to another parliament. The American idea of a non-delegation doctrine has no application in Privy Council jurisprudence. Their lordships considered the fact that Section 917A predated independence, and thus predated the Constitution, to be irrelevant, because the Parliament of St. Lucia has always had, in the 44 years of its proud independence, the complete and sovereign power to change 917A whenever it liked to do so. There was no parallel lawmaking authority, because 917A provided that any act of the Parliament of St. Lucia superseded imported English law. Now, the definition of sovereignty is, put simply, the ability to do whatever one wants. And here, the Parliament of St. Lucia has exercised its sovereignty to choose to delegate certain legislative matters to the Parliament of the United Kingdom. Now, the appellants also raised a technical challenge to Section 917A. Section 47 of the Constitution requires that bills be approved by both houses and published in the Official Gazette, which, of course, the United Kingdom Defamation Act was not. However, this kind of submission was already rejected by the board in the well-known case of the Crown Against Christian No. 2, 2007-2 Weekly Law Reports, page 120, Privy Council, Pitcairn Islands, which dealt with the fact that provisions about the form of acts of the legislature apply only to that legislature's acts, not to foreign laws incorporated by reference. The second issue their lordships considered was precisely what law was imported by Section 917A. Mr. Hilaire argued it should import only the common law of defamation, but not the statute law. Their lordships were not impressed by this submission. 917A used the term the law of England, which naturally, in ordinary language, includes both common law and statute law. Moreover, previous cases, such as Thompson and the Queen, 1998 appeal cases, page 811, Privy Council, St. Vincent and the Grenadines, had found that law of England included statutes. Additionally, it would make little sense for the statute to just adopt the ambulatory common law but not the statute law, since statutes freeze and replace the development of the common law by legislation, with the result that the common law would be left orphaned, frozen in time. Now, this raises the question of just how ambulatory this provision is. Their lordships cited a line of case law and academic authority that, for the time being, includes law as it changes and evolves, subject to the provisions of the Civil Code. And thus, the Defamation Act and every other act relating to torts and contracts in 917A was validly imported. Now let's turn to the final issue. Is the Defamation Act 2013 inconsistent with provisions of the Civil Code, and therefore superseded by those provisions? The main area of potential conflict relates to limitation periods. The 2013 Act reformed defamation limitation by making the cause of action accrue from the first publication of a libel, and not reaccruing from every subsequent publication. So, to make this clear, if I publish a defamatory podcast in March, and then rebroadcast that podcast in April, the cause of action against me has a 1-year limitation starting in March, not in April. Meanwhile, the Civil Code also provides in Article 2123 that libel actions accrue, quote, from the day that it came to the knowledge of the party aggrieved. Their lordships saw no contradiction here, because read together, it merely means that limitation accrues when the plaintiff first gained knowledge of the defamatory material, and not from subsequent knowledge of subsequent publications. In a similar fashion, their lordships also dismissed some other challenges to other parts of the Civil Code, all of which they, in a similar manner, found consistent with reading in the 2013 Act. Thus, the board humbly advised His Majesty that the appeal ought to be dismissed. Turning now to our analysis of the case, we see here the operation of a strange but rather common post-colonial legislative framework, ambulatory reception, by which a country agrees to have a standing order, if you will, for continually importing the laws of another country. This can seem from the outside to be a colonial relic or the sign of a failed legislature or a partial ceding of sovereignty. That is a mistaken outlook. St. Lucia is an independent and sovereign state. It is also a very small country, just 180,000 people. I have linked in the show notes to a very good article from the Commonwealth and Comparative Politics Journal by Abrak Sati, which examines the challenges of legislating with limited resources. The St. Lucian Senate has just 11 members. The Parliament of St. Lucia has judged that it is more efficient and helpful to its citizens to use an existing body of law from England to govern private law, rather than try to reinvent the wheel. This is a legitimate policy choice to make, and one that is rational under the circumstances. The claim that this is somehow not allowed under the Constitution ironically undermines the sovereignty of St. Lucia and the plenary power of Parliament. St. Lucia's use of England's substantive and procedural law for defamation and other matters frees Parliament to deal with other issues, and it is always kept in check by the Civil Code and the Constitution, both of which supersede any other matter. Just as St. Lucia was free to depart the Privy Council for the Caribbean Court of Justice, so is it free to continue importing English law to their own legal system. In both cases, the democratic decisions of the St. Lucian people, via their MPs and senators, should be respected, not derided. Thank you very much for listening to another episode of In the Privy Council, brought to you by the Legal Style blog. If you want more legal content, visit our website, legalstyle.co.uk, or follow us on Twitter @LegalStyleBlog. If you have any comments, suggestions, rants, or raves, the email of the podcast is editor@legalstyle.co.uk. Until next time, goodbye, and God save the King.